Hello, everyone. Welcome to this recorded lesson about copyright, data ownership, and reuse. This is the 12th recorded lecture of a series within the project H.E.L.P. My name is Thomas Margoni. I'm a research professor of intellectual property law at the Faculty of Law at the University KU Leuven in Belgium. My research focuses mainly in the area of copyright law from an international and comparative point of view. And I apply most of my analysis to new technologies, so to the internet, to the process of digitization, and to the data economy, so the way in which data and information have become central to the process of production, consumption, and distribution of knowledge. This lecture is a part of a series within the project H.E.L.P, which is a project for the digital heritage institutions. And within this broader framework, we are focusing on selected legal aspects. Today, the selected legal aspect of choice is copyright. You are already familiar with the topic, but today we will be focusing on a specific relationship between this broader area of law and the issue of data ownership and data reuse. We will start from some basic principles. We will spend a couple of words going over again what copyright does, what is the main function of copyright, and in particular in relation to the issue of the distinction between what are protected expressions and what is not protected by copyright. So the usual way in which we report one of these fundamental principles is that copyright protection extends to expressions, not to ideas, not to procedures, not to methods of operations, mathematical concepts as such, or to news of the day or facts having the character of mere items of press information. Here in the slides, you have the legislative references. This is only a selection. These are fundamental principles that are enshrined in some of the most important, influential, and widespread international conventions in the field. So the WCT is the World Copyright Treaty, administered by the World Intellectual Property Organization. TRIPS is a trade-related aspect within the World Trade Organization, and the Berne Convention is the oldest copyright convention in the field that has been signed as of today by more or less 190 member states. So at this point, it should be clear how much these general principles are not a matter of a single jurisdiction or legal system or area, but are really those principles that with obvious distinction and differentiations from country to country, because then it will be a matter of the law of the specific country to give them a specific shape and content, but the overall principle is the same. Ideas as such are not protected by copyright. Only original expressions of those ideas are protected. The usual example that we do in class is to say that a book, for example, about a doctor who creates a monster made of part of bodies and then tries to give him life. This idea is not protected, but the specific expression that Mary Shelley gave to to her novel, that expression is protected. And we could make many other examples in every other field, because copyright applies to literary and artistic works, which means every production in the literary, scientific, and artistic domain, whatever may be the mode or form of its expression. And the examples here are just illustrative, but they go from books, pamphlets, and other writings, lectures, addresses, musical compositions, cinematographic works, drawing, paintings, engraving, photographic works, etc., etc., etc. So really a very wide typology of works that are protected. The form of expression usually doesn't matter, but there must be an expression. Again, the main element here is that ideas as such and other non-expressive elements such as procedures, concepts, etc., are not protected by copyright. Now, moving slowly from this general principle to the more specific area of data and databases, we have to look for some definitions. We don't really find clear definitions of what data is in copyright law, but we do find the expression, and we do find definitions that help us circumscribe this area. So one of the first definitions that we find is that of a database, which is a collection of independent works, so something protected by copyright. Data, something not protected by copyright, or other materials, a kind of residual category, which especially in certain countries help us to include what we call other protected subject matters. So items that are not protected by copyright, but may be protected by rights related to copyright. And the examples here could be performers' performances, sound recordings, in Europe, the first fixation of films, broadcasts over broadcasting organizations, and then the list can go on and include typographical arrangements, scientific and critical editions of public domain works, etc., etc., etc. Maybe a very, very big list. This, other materials is really a capture-all category. But what is important here for the database definition is that we need to have a collection of something. And this collection has to be arranged in a systematic or methodical way. And often here we have the expression, well, I have a data set or have some raw data. Well, we don't have this definition in the law, right? However, not in copyright law at least. However, certainly on a semantic level, it may be argued that raw data, so undefined, unstructured amount of data or an unstructured data set lacks this characteristic of systematic or methodical way. Sorry. If this is the case, then we don't have a database. So it's very important for the existence of a database to have this element of systematic or methodical arrangement. Again, I repeat, raw data, unstructured data sets, these are not legal terms. So it really depends what you mean by that. I cannot discuss this aspect because these are definitions that are not given, for example, here in the database directive. But we have a definition of database. So that's what really should govern our analysis when we want to find the legal dimension or the right legal categorization of these concepts. So this is a database. Another interesting definition is that of mere facts and data. We do not really have a definition of them. However, they are there are indications in various legal sources, especially new directives, that mere facts and data are not protected by copyright, or that copyright should not extend to mere facts and data. And examples of this are recital 45 of the database directive or 9 of the corporate digital single market directive. But we have many more examples, both in the case law of the Court of Justice and in other legal sources, also at the international level. Here, usually we refer to the fact expression dichotomy. Facts are not protected, but if we take these facts and we arrange them in some sort and we add an expressive element which is original, then that's what leads us to a protected expression. More recently, and not in the field of copyright, but in another area of law that we will briefly see towards the end of this presentation, we have the definition of research data. That's quite interesting. Research data is defined as the documents in a digital form other than scientific publications, so not scientific publications, but anything else, which are collected or produced in the course of scientific research activities and are used as evidence in the research process or are commonly accepted in the research community as necessary to validate research finding and results. So this is also quite interesting. You know, let's keep this definition in our mind or on the slide for now, because they will become quite relevant in a moment. Let's start with the database. So I told you what is a database. At this point, you could say, okay, fine. I know what is a database, but what does it happen then? Well, the question is, we are looking at the ownership or copyright dimension of data. We have said that data as such are excluded from copyright protection, but data could be structured in a database if this structure is what meets the requirement, the definition that we have just seen. What happens when it does? Well, things here starts to get a little bit more complex. If we have a database as defined in the directive, so it's defined in the slides that I just showed you, then we may encounter two layers of protection. The first one is copyright. Again, the right that you already met, that you already studied in a previous lecture, and that behaves as you know. So there are certain moral rights, certain economic rights, certain exceptions, etc., etc. In the specific case of database, it's important to keep in mind that copyright exists in a database if and only if the selection or arrangement, so the structure of the database, so the selection or arrangement of the content constitutes the author's own intellectual creation. So there needs to be originality in this structure. The easiest example that I can think of, and usually helps, I hope it does here as well, is that of the traditional spreadsheet. You have your spreadsheet, you have your row, your column where you insert the parameters. And let's say that you are collecting all the entries in a range, let's say all values from 1 to 100, no selection, all of them exhaustively. 1, 2, 3, 4, 5, 6, 7, and you are presenting them. That's a bad example, but you know, you're presenting them also in a way that doesn't require any originality. So, for example, you present them alphabetically. Let's make the example of phone numbers. Names and phone numbers. Let's say that you collect all the phone numbers in your town. If you arrange them alphabetically and you select just all of them, there is no originality here because you're following a very basic approach. Exhaustive collection, alphabetical order, no originality, no copyright. But if you select them with some element of originality, with some element that can reflect your own intellectual creation, you select only some of these entries because they represent, you know, something relevant for your research or for your archival purposes. and or you present them in a way that is not just alphabetical, but you present them following certain categorizations that you have developed. Then in this case, there may be originality and the database may be protected by copyright. However, remember that originality is the gateway to copyright, and therefore copyright will only protect the original element in the work. In this specific case of the database, it means that if copyright protects the database structure, then only the database structure and not the content are protected. Therefore, in our case of the spreadsheet, only the way in which you have created the structure, so the selection and arrangement of data is protected. So the same structure could not be replicated by anyone else without your authorization. But the content, the phone numbers that you have included, these are not protected by copyright, at least not by the copyright in the database. We will see if something else can happen here later on. Therefore, someone else could extract and reproduce or copy your data. Not the structure of the database, but yes, the content of the database. Could, not shall, because other rights may help you out here if your intent is that of finding a form of protection. So the second layer, it's called sui generis database right. It is a quite a unique right, so unique that the best name we could find it was sui generis. And at this point, we are entering into a peculiar European Union law structure. So what I told you so far, more or less with some differences, applies, I would say, globally. These are principles up to these slides that are present at the international level, and therefore, obviously, different countries may apply them differently, but the broad principles are the same. The sui generis database right is a pure European creation. It is a second layer of protection for databases that does not protect originality, but protects the substantial investment. So in order to trigger, to activate this right, you as the database maker have to show that there has been a qualitatively or quantitatively substantial investment, and all these requirements would need to be defined, of course, in either obtaining, verifying, or presenting this content. At this point, if these requirements are fulfilled, then rights that protects against substantial extraction activates, is available. So again, here things become a bit more blurred. We are not protecting data. The single datum, it's still unprotected because, 28 cannot be protected. However, if you have collected or presented or verified data in a way that require the substantial investment in time, effort, money, then this database right, the sui generis database right, may become available to you. And in this case, what is protected is the substantial investment, but because the form of protection is against extraction, so making copies of this content of substantial amounts, there is a form of protection. It is said that this form of protection extends to data, not to the single datum, because data as such, as we saw, are not protected, but a substantial amount of data, when they reflect the substantial investment of the database maker, then in this case, protection is triggered. I know it may be a bit confusing, but that's how it is, at least until now. Don't worry, it will get a little bit more complicated. So just before we look at a possible third layer of protection in the case of databases, let's have a quick summary of the differences between copyright and the sui generis database right SGDR for databases. So copyright protects the selection and or arrangement, that is to say the structure of the database when original, whereas the SGDR protects the substantial investment in obtaining, verifying, or presenting the contents. Very importantly, only investments in obtaining, verifying, and presenting data are qualified. If it was shown that there has been a substantial investment, but this substantial investment was in creating the data, well, in this case, there is no protection. This usually, especially in the scientific field and sometimes also in the cultural and creative heritage field, it raises eyebrows, because one could say, well, wait a second, if I create something, I'm not protected, but if I get it from somewhere else, I am. Yes, because this is not copyright. Here we are not protecting originality. Originality is something that originates with you, with the author. And because you go through this creative activity, this externalization of your personal views, this investment of time and effort, then that is the gateway to protection. But in the case of the SGDR, what we protect is the substantial investment. And we're really in a different area of law, an area that we could define more connected to favoring a competitive market, so offering incentives to the creation of databases. After all, this is the database directive. However, there is an element that, especially from a competition point of view, we have to keep in mind. The creation of property rights may offer incentives for investment, but may also slow down innovation when they are too many. In the case of created data, a possible danger is that the only source of this data, let's say the meteorological office, that is the only office that takes these measurements for, this specific location, if they could be entitled to a property right, well, the only possible source of this factual information would be protected by a property right. And this could have highly anti-competitive effects for the economy, but also strong anti-freedom of research effect for science, and also anti-freedom of expression effects for society in general. Therefore, the idea is that if you create this data, well, there is no protection. But if someone else obtains this data and invests money in obtaining them, then they can obtain protection on this database, because other competitors will not be able to copy this database, but will also be able to go back to the source to create competing databases for the same service. And that's how competition, innovation, and market structures are made efficient. Again, a bit complex, perhaps not the most obvious form of reasoning for the cultural and heritage sectors. But as I said, the reason for this provision is strongly grounded in competition law issues. The structure of the database, when we talk about copyright, is what is protected, not the content, only the structure. But keep in mind, copyright on the database, we will see that there will be a third layer, which is copyright in the content, but more on that later. When we have a sui generis database right, what is protected is the substantial investment. That's the object of protection. However, in this case, really, we have a de facto extension of protection to the data contained in these databases, not the single datum, but a relevant, a substantial part of this data. The term of protection is also quite different. In the case of copyright, is the life of the author plus 70 years. In the case of the 𝑠GDR, it's 15 years from creation, but is renewable. Copyright normally belongs to the author, but in case of databases, economic rights may belong to the employer. Then it depends on the specific member states implementing the database directive, whether they take advantage of this provision or not. So this needs to be checked against applicable law and also in the light of contracts, because an employment contract or, let's say the policy, the IP policy of your institution may say differently. The 𝑠GDR belongs to the maker of the database. So usually the person, natural or legal, that bears the financial risk. So again, the 𝑠GDR and the copyright on the same database may belong to two different persons. Exceptions and limitations, again, they are different for copyright in the database. We have to look at Article 6 that talks about lawful users plus 4 specific cases. We don't enter into the detail. In the case of the 𝑠GDR, we have a similar structure, but the point is that these exceptions are online, but are not made mandatory for member states. So here we're talking about a directive, right? So this is not directly applicable to you, but it's a directive that is sorry for the play on words, is directed to member states of the European Union. These member states have to take this directive and transpose it into national law. And in doing this, they can choose whether to implement or not these exceptions. So it may well be, and it happens, that the exceptions that apply to copyright on the database are different from the exceptions that apply to the 𝑠GDR in the same database. Again, it's important to keep in mind that copyright and the 𝑠GDR are independent. So we may have a database that meets the definition, and the database may lack any originality in the structure, so no copyright, and lack any substantial investment, so no 𝑠GDR. Still, we have a database, but it's not protected, at least as a database. But the same database may have originality in the structure, copyright, may have no originality in the structure, but substantial investment, 𝑠GDR, or both. So it could be protected by copyright and by the 𝑠GDR. So they are independent, but cumulable. It is important to note that more recent exceptions, such as the Article 3 of the Copyright in the Digital Single Market, so the text and data mining exception created by the European Union, apply both to copyright and 𝑠GDR. So here we have, let's say, a good news, because at least we have a provision as important as text and data mining for the case of, we are looking at data protection and data reusability from a copyright point of view. Then it's important to know that Article 3 applies to both copyright and sui generis database right. And it's particularly important because Article 3, the text and data mining exception, is not available to everyone, but the beneficiaries are limited. Only research institutions and cultural heritage institutions. So museums are included. So museums can take advantage of this exception, and this is an important, certainly important aspect. So at this point, I told you that we have 2 layers, but just because we are more or less halfway through our presentation, I can tell you that I lied to you. We not only have 2, but in fact, we may have 3 layers. Which one is this 3rd layer? Well, the 3rd layer is that of the content. If you remember, when I told you, when I gave you the definition of a database, we saw that a database, it's a collection of works, data, or other material. And so far, we have looked at the type of protection that we have in the structure of the database or in the investment in collecting the data, not in the data in itself. But the data in itself may in fact be a variety of things. Let's have a quick look at this option. So the first case possibly the simplest, is where the content of the database is mere facts or data which are not protected by copyright. Remember, we saw it at the beginning in our definitions. A database of temperature measurements. Well, in this case, we don't have third layer because the content is not protected in its own right. But another option is when the works, so the content of the database are works. So think of a database of protected images or a database of journal articles or of movies. In this case, we may easily have three layers. So we have the copyright in the database structure. We have the substantial investment in the making of the database, so the SGDR. And then we have the copyright, the independent copyright in the element constituting the databases. So three different layers. We could have other protected subject matters. Here we don't need to spend too many words, but these are rights similar to copyright, but they are not really copyright. Sound recordings, non-original photographs, all these examples. And then a category that deserves to be mentioned is obviously that of personal data. So the case in which we have a database of personal data, for example, a database of names and emails. In that case, the names and emails are not object of copyright protection or similar property right protection. Nonetheless, they are protected. They may be protected by personal data. Now, this is very important to keep in mind that everything I'm telling you today focuses on copyright, not on personal data. These are two very different areas of law, and the way in which they are regulated and in the way in which reuse may be granted follow very different routes. That's why we are focusing only on the copyright side today. So at the end of the day, what is important to keep in mind is that we may have up to three different layers of protection of different rights on such a simple thing and a common thing as a database. This is very important to keep in mind because obviously, if you want to favor reuse of this database, you have to ensure that you address the rights at all layers, at all different layers. And obviously, this may be more complex than what would be the case if we only had one layer or two layers. So for example, when you have created this database and you want to share it applying a Creative Commons license, or when you're a user and you want to reuse a database with a Creative Commons license or any other type of license or without a license, you have to keep in mind that you're dealing with this complexity, with these three different layers. In the next few slides, I'll try to give you a few pointers about how this may look like. Obviously, I'm not going through any analysis of Creative Commons licenses because, again, I know that you have already discussed them, so I give for granted you are experts. But for the relationship of between Creative Commons licenses and databases, I think that the next few points are quite interesting. So we start with the CCPL, so the Creative Commons Public License. Usually it's never called like that, but this is the proper name. Attribution, so the most, let's say, basic and liberal one. 4.0, so that's very important. Always use the latest version available, and for a few years now it has been 4.0. This is especially important for the sui generis database right, because previous versions 3.0, 2.5 regulated the database, the SGDR, in a different way. So if you notice that, we cannot discuss it today, but feel free to contact me or to look for all the information available online. But keep in mind, it may work differently. If you have a 4.0, that's the best situation possible. So we said attribution is the most liberal one. It only requires attribution. It applies to the whole work in front of you. So it kinds of try to solve this legal complexity on your behalf. If you see a database and this database is licensed with a CC BY, then it means that the copyright in the structure of the database, if any, the SGDR in the substantial investment, and the copyright in the content, they're all under a CC BY license, usually unless otherwise noted. And this makes your life, if you are a reuser, or even if you are the right holder and you want to apply a license, much easier, because you don't have to address this complexity, these 3 layers that we saw. You can just only have a look at the fact that is a Creative Commons license 4.0. Then you know that it applies to all possible layers. Again, not personal data, right? We are not talking about personal data. Personal data is not copyright. If there is a CC BY on a database, and this database also contains personal data, it doesn't extend to personal data, because personal data is not regulated via copyright, and CC licenses are copyright licenses. So if you read the license, and I know that no one ever reads a license, Creative Commons or any other license, but believe me, they do not address personal data issues. They are completely different. So keep that in mind as well. So this is very good, because we only got one license to solve all our problems. But this is the approach for CC. Other approaches may be different. So there is a common example that is usually made, that of OpenStreetMap, that combines other type of licenses, one for the database and one for the content. It's a different approach. Sometimes you don't have you're not the right holder of the content, and therefore you cannot apply a license to the content. So in these cases, you can still license your rights in the structure and eventually in the substantial investment if you made them, but you cannot license something that you don't own, such as the content. So this is an interesting element, maybe makes things more complex, but is always good to keep in mind. If the database is not protected at all, so no originality in the structure, no SGDR, not copyright in the content, the license is not triggered. Keep in mind that in the case of open licenses in general, certainly in Creative Commons licenses or in FLOSS licenses, the license is only triggered if you use it's otherwise reserved by copyright. If your use is not reserved by copyright, then the license doesn't apply. So the restrictions of the license do not apply to you. That's how it works. It's a mechanism. It may sound, again, counterintuitive, but is a very important mechanism that characterizes open licenses. And the same when your use is based on an exception, such as the text and data mining exception. In these cases, if you perform text and data mining and your use is covered by the exception, then you don't have to look at the license, because the exception allows you to do what you intend to do. Again, it's very important to keep in mind this aspect, because museums as a category of cultural heritage institutions are considered beneficiaries of Article 3 Copyright Digital Single Market Directive, and therefore can perform TDM activities on this basis. There are other licenses. Again, we don't want to go into the detail. For data as such, when only the SGDR is present, usually it's CC0 that is recommended. And the reason is because from a legal point of view, the situation of a non-protected database where only the SGDR exists and CC0 is where you have a much better alignment of the different rights. Finally, a few words on the public sector information, open data, and museums. Public sector information is an area of law that is, it's different from copyright. It's not copyright. But I think it's quite important to mention it because the latest review of the Public Sector Information Directive, the 2019, tells us quite a number of interesting things. So here I will only go through the main one, but I think it's important for you to to be aware of these aspects. So Article 1 that tells us the overall scope of the PSI legislation tells us that in order to promote the use of open data and stimulate innovation in products and services, the PSI directive establishes a set of minimum rules governing their reuse and the practical arrangement for facilitating the reuse of existing documents held by public sector bodies and research data pursuant to the condition of Article 10. So these things, the documents held by public sector bodies, including libraries and museums, and the research data, fits into a general principle of reuse by default. There are obviously areas that are excluded from the directive, documents for which third parties hold intellectual property rights. So if anyone other than the cultural establishments hold an intellectual property right, then that document does not fall under this reuse by default rule. But also documents held by cultural establishments other than libraries, including university libraries, museums, and archives, which means that for the case that we're analyzing today, this reusability by default, it's something that applies to libraries, museums, and archives. Article 3 reminds us that member states shall ensure that documents to which this directive applies shall be reusable for commercial and non-commercial purposes in accordance to chapters 3 and 4, which set forth a number of detailed rules for these reusabilities. Important to keep in mind that for documents in which libraries, including university libraries, museums, and archives, hold intellectual property rights, so when the library, for example, is the maker of the data of a database, member states shall ensure that where the reuse of such documents is allowed, so it's a different decision whether it is allowed or not, but if it is allowed, then those documents shall be reusable for commercial and non-commercial purposes in accordance to chapter 3 and 4. We don't go through chapter 3 and 4, but they set quite clear requirements relating to transparency, to fees that may be charged, to other regulations that should be followed when a request for access or reusability is filed. It's very important to keep in mind that the right for the right of the maker of a database provided for in Article 7.1 shall not be exercised by public sector bodies in order to prevent the reuse of documents or to restrict the reuse beyond the limits by this directive. So that's quite important as well, and quite interesting, because in the PSI directive, we have a regulation, we have something that tells us that the SGDR does not apply in this specific case, which is also quite interesting. And finally, that the reuse of the document shall be free of charge. So you cannot charge for the use of these documents. There is an exception for libraries, including university libraries, museums, and archives, which are excluded. However, and here I let you read the provision, the total income from supplying and allowing the reuse of the documents over the appropriate accounting period, etc., etc., etc. It means that you cannot generate a profit out of this. You can cover your costs, but you cannot really generate a profit as a business model. Why? Because these are public data and they need to be made reusable by default. So this was the last slide. It's a lot of information, but I think it's quite interesting to observe how these various legal provision in different areas intersect. I hope you find this lecture interesting, and please feel absolutely free to contact me should you have any other questions. Thank you very much.